Hello, everyone. And on behalf of Scott and myself, we'd like to welcome you to another version of the Wisconsin Bankers Association Compliance Corner. Happy spring to all of our fellow Wisconsin bankers. We know it's been quite the roller coaster ride here these last few months. So as our normal routine, we have an agenda of items that we would like to cover for you in this particular video, which we're going to flip to here just very shortly. And as our normal practice, we will also have links for each of the items that Scott and I will be covering this morning as we walk through the various topics, the items that the agencies have issued here just recently. So with that, let's jump into the fun topics that we're going to be covering today. And a little bit of a heads up, it's a little bit beefier one. Topics are a little bit heavy, a little bit more legalese talk than what Scott and I typically try to do when we relay information to our fellow bankers. But nonetheless, it's important information. So we're first going to take a look at the resources that were issued here just this week by FinCEN as relates to the beneficial ownership information that our businesses will be reporting to FinCEN. Also going to be covering a lot of information on the very serious topic of discrimination in appraisals. There's a lot of focus on this, and we certainly want to make sure that you are well prepared for examination inquiries, interests, and just know what's going on out there. We also have the return of HUD's 2013 Disparate Impact Rule, and then we are going to be covering a bunch of different agency kind of heckledy-peckledy topics ranging from loans and deposits. But there's some information out there that we want to make sure you're aware of the resources, and we've got the different topics listed here. You might see, oh gosh, HMDA reference charts. You guys covered that last month, which is true, we did. But as Scott will illustrate for you, there's been some changes to that. So make sure you're pulling the most current charts, and then of course some court cases that we want to make sure that you are following, and both on the federal and on the state side. So with that lineup, let's turn it on over to Scott for some specifics here.
All right, thanks, Heather. So yeah, we're going to start with our FinCEN item here. So obviously we've had the beneficial ownership rule reporting requirements for a while for banks now, and FinCEN has provided updates to that. But what we're looking at here and have been looking at for a while now are some updates and new rules that FinCEN is implementing with regard to the overall beneficial ownership reporting scheme and the whole goal there of collecting information from businesses. And this comes from the Corporate Transparency Act. And what we've been seeing from FinCEN is the implementation of all the various provisions that it is required to write rules on. So for example, last December, we just talked about the safeguards provisions that we had. Again, the overall goal here with the Corporate Transparency Act being to really buff up the system. So to gather information through FinCEN to get through those shell companies and reach the bad actors, and better be able to be equipped to combat financial crimes that are going on through these businesses. So then with that context, this specific release here that we have for you on slide 3 is a final rule from FinCEN that was issued last September, again, as part of that scheme, as part of implementation of the Corporate Transparency Act. So another component of that. This rule requires the reporting of beneficial ownership information for certain registered entities. So for corporations, limited liability companies, and other entities, all of those that are registered. So what we have here now, released from FinCEN just recently this month, is a set of guidance materials. These are particularly to assist businesses with understanding the reporting requirements that are going to come into play. And those are going to be effective on January of next year, on 2024. And what you'll see is there's no early reporting. That's the date. And so FinCEN is ramping up and preparing and issuing guidance, this being the first set, to help businesses prepare for that. So in addition to the reporting requirements that banks have, businesses are also going to have, certain businesses are going to have reporting requirements as well. So at this time, FinCEN has set up a website that has a lot of good information that lays it all out in different formats on beneficial ownership reporting. And in this first wave of guidance, they've just recently put out FAQs. So you can find frequently asked questions centering on who has to report, what has to be reported, what is a beneficial owner, all of those key questions on, what this rule entails and really what it means, kind of the who, what, where, when. There's a timeline of filing dates, including what is required for initial reports and the procedures for corrections and updates. And these are in FAQ format, and they also have kind of infographic formats as well to kind of show what this is going to look like through the steps of implementation here. Then there's also 2 videos as well. There's an introductory video just giving the basics on it, and a longer one that goes into more details on the specific requirements. So a lot of great resources there to see and understand what's coming up. Again, this will be in January of next year. This is the first set of guidance, but it does a good job of laying everything out on what's going to be required for this whole new set of reporting that's going to come into play in addition to what we already have. Moving on, our next slide, on slide 4 here, we have the topic again of discriminatory appraisals. And you can see we've framed this as an agency focus. So we're going to look at some specific parts in here, but we really wanted to bring this back to attention because of the increased agency focus on the area of appraisal bias and discrimination in appraisals. So this is not a new issue. In fact, we talked about it last fall, but wanted to bring it back to your attention and specifically give you the CFPB blog post along with some other resources. So what you'll see on this slide are all of those kind of topics in each bullet, along with a link, a asterisk corresponding to the link that you'll find down below for a resource that is emphasizing this concept. And that is, again, continued focus on discriminatory appraisals. Specifically here, we have CFPB and DOJ. So through ECOA and the Fair Housing Act are focusing on consumer protection, specifically when it comes to the housing market. So again, the efforts there are on fair access to home ownership, access to financing in home ownership, and specifically discriminatory residential valuations and appraisals, and how that can affect home ownership, access to home ownership, access to credit for home ownership. And again, the number of links here in the description below, along with a summary of everything on the slides here, is worth looking at to really see what's happening here from an agency perspective. So the first one on CFPB and DOJ's perspective starts really, this really starts with that blog post. And that blog post involves a discussion of this case. So we have a link to the blog post itself where you'll see kind of a summary and why CFPB and DOJ are looking at this and why they have issued a statement of interest that we'll talk about in a moment as well as a link to the case itself. So the case, Connolly and Mott v. Lanham, what you'll see is that this involves a Black family that was seeking to refinance, and they had their application. So they had a pre-approval and an application, and they went in and got an appraisal that ultimately resulted in denial of that application. Reason being, the appraised value came back at $472,000, and without getting into the details, the appraisal was denied on that basis. Subsequently, after that, what this family then did was whitewash their home, which involved, among other things, having a white friend stand in for the appraisal, which then came back at $750,000. Okay, so what happened from there is this court case, CFPB and DOJ provide the summary of it, and in review of that court case and in interest of that court case have since filed a statement, in short, summarizing that mortgage lenders can be liable under FHA and ECOA for relying on discriminatory appraisals. So really here we have a specific example, right? But we also see that CFPB and DOJ is taking great interest in this. And it's not just this specific example, right? But that concept that lenders can be liable for that, and emphasizing the fact that, we need to be aware of the appraisal process. We need to be aware of how these are being made, how they're being reviewed, and how they're using, even where the lender itself didn't generate this, or maybe didn't take any active discrimination here, but it was the appraiser, right, that generated this. And because of that fact, and because of the fact that the lender was relying on it, can still be liable for that. Again, so we have a link to that blog post, which is worth taking a look at, which discusses the case, a link to the case, a link to the statement of interest as well. But again, that's kind of the nexus for that. But the broader perspective being this discussion that we need to be aware of the renewed and increased agency focus on appraisal bias. Along those lines, we then have a couple of other items on this slide. So CFPB's Small Business Review Panel had recently put out an outline as well. And so an outline of proposals, this is specific to automated valuation models and rulemaking in that realm. So that would be the standards for accuracy and fairness regarding computer-generated appraisals and valuations. So again, similar, but here where we have these algorithms and these formulas, right? It's all automated, it's all computerized, going through this system, understanding what that process is like, and ensuring that there's fairness in that process as well. Even though it's automated, right, and it's going to be set to an objective set of standards, we still need to understand what those processes are. And I think importantly as well, understand that CFPB is exploring what those standards will be through the rulemaking process. So we know that CFPB is looking at this. We can certainly expect a notice of proposed rulemaking soon as well, possibly even yet this spring or later. Regarding these automated valuation models, these AVMs. So that's going to be something to keep an eye out for. Then we also have a link to the PAVE action plan. And this is an interagency task force on property appraisals and valuation equity. This is led by the White House. This is something that the Biden administration has been promoting, and it is composed of numerous agencies that are dedicated to this purpose, right? Again, this is a task force. Again, exploring how we can create fairness in access to credit and access to home ownership. I won't go into too much more detail, but we wanted to include this to show that emphasis, right? Fairness in the appraisal process, and that link is included as well. And then just one last thing I thought we would mention as well, just along the lines of understanding that the agencies are collecting this data. We have the Small Business Review Panel. We have that study from CFPB. All the agencies are doing this and preparing. Along those lines, FHFA has a public meeting coming up yet this spring in May as well with their appraisal subcommittee. So the agencies are active here. We're going to be looking out for what rules we have coming down, making sure we understand what new set of standards there may be, again, with the goal of fairness and encouraging everyone to consider that as well in preparation for reviewing your own policies and procedures in your own appraisal and valuation process. And if you are using those automated models, understanding those systems, understanding how those work, understanding the process of how you're getting these appraisals from your appraisers, how you're reviewing them. So again, all of those sets of information we went through, there's quite a few of them on this slide. You can see those asterisks and the links to any of them down below that you would want to take a look at and explore further. But with that, I will turn it over to Heather.
Thanks, Scott. Yeah, on that topic of appraisal, we just wanted to make sure that it's on your radar. Examiners are asking in examination settings about what banks are doing to watch for and monitor what the appraisers are doing, and even in valuations. So be aware of it. Make sure that you've brushed off your appraisal policy. Make sure that you're prepared to answer those questions of how do you spot, how do you double check valuations to make sure that something isn't really, really wonky and you're relying upon it. So again, a lot of information that Scott covered on that slide. It's important to read through that PAVE action plan. The banking agencies are actually part of that committee as as Scott mentioned. And so we're anticipating rule writing down the road, but most importantly, be prepared for it in an examination setting. And if you've got questions about anything that you're reading about appraisals, feel free to reach out to Scott and I. So the next topic that we want to make sure that are on your radar is something that's resurrecting itself from a few years ago. It's HUD's Disparate Impact Rule. And so for those of you who have been in the industry for a long time, you're aware of this rule. We do have some newer compliance folks, so maybe this is the first time you're hearing about this, but it is a very important rule. There's been much litigation on both sides of the equation as it relates to this particular standard that we're going to be covering here in just a moment. But it's important to know that it's coming back, and it's not yet been issued in Fed Register, but it's going to be in the Federal Register here any day now. So Scott had made mention to the Fair Housing Act, and so we have kind of a little refresher here for you of where you find it. It's Title 8 of the Civil Rights Act, otherwise known as the Fair Housing Act, and it's meant to stop discrimination. And the keeper of this particular area of law, the agency that's primarily responsible for it, is HUD, so the Department of Housing and Urban Development, but the banking agencies tie into HUD's authority and piggybacks back on HUD's authority and their interpretations when it comes to the Fair Housing Act. And so our banking regulators walk very closely in step with what HUD has determined as being the threshold used to prove that somebody has violated their Fair Housing Act. So we had this rule back in 2013 that was the gold standard for if you were subject to a lawsuit where a party, someone who was harmed, or even HUD, claimed that an action by the bank violated the Fair Housing Act. The prongs that were used within the court case to show that violation stemmed from what was called the 2013 Disparate Impact Rule. Still going back in time, so that was in 2013. Back in 2020, there was a revision to what those elements, what those prongs were. And upon that rule being issued, there was a court case, and the court stayed the implementation of that 2020 rule. So we've kind of been in limbo for the last number of years because of that court action. Well, HUD then took comment on whether or not the 2013 rule should come back, or do we stay with the 2020 rule? And they received thousands of comment letters, like tens of thousands of comment letters. And as you can imagine, there were proponents on both sides of the equation of why the 2020 rule was better and reflected discrimination effects currently. And then there were others that thought that the 2013 rule was a much stronger tool for showing discriminatory effects. So after all of that, HUD has decided to resurrect, as I mentioned, the 2013 Disparate Impact Rule. So that's what we're going to be having here. It'll be effective when it gets published into the Fed Register. And the important components of the case, not to get too nerdy on you with legal information, are the bullets on the bottom portion of the page. And so what it really does is it sets forth the legal standard of what parties are supposed to do, in fact, in a case setting. And so we have the first prong being that someone who believes the bank has taken an action or done something that has a disparate impact, has a negative, has a discriminatory impact based upon a practice. That person or that entity is the person who first bears the responsibility, the burden to prove that the bank's practice resulted in a negative impact and a discriminatory impact. Once that burden has been established, then it's the bank's responsibility to respond and to say that no, the way that we did something or the way that we had a procedure, it was legitimate, it was necessary, it did not result in discrimination. The bank would have that burden to overcome the challenge that was being made by the harmed person or the person who's claiming the bank was doing something wrong. After the bank establishes their proof for making the claim that their actions were not in violation of the Fair Housing Act, then the party who's asserting, so the plaintiff, the party who's asserting that the bank acted incorrectly, still has the opportunity to come back and rebut all of the different steps that the bank put forth, and also then has the opportunity to say that, no, we get where you're coming from, but you should have done it a different way. You should have taken different steps, and the different steps would have not had the same negative discriminatory effect, and you would not have violated the Fair Housing Act had you taken these alternative steps. And then the court would make its determination from there. So the 3 prongs are very important prongs, and it's something that you'll hear more about as we go forward underneath this 2013 standard. But the standard is onerous. The standard is lots of gray areas, and can make fighting a Fair Housing Act violation suit difficult. But know that this is that the old law is coming back into play is kind of what we wanted to make sure that you're aware of. We have provided you a link to read the rule that is going to be coming down. There's a lot of helpful information in the commentary section, the preamble part of the rule, which explains the comments that people had submitted and the rebuttal by HUD as to why they brought the rule back. So that'll be an important read for those of you that have the responsibility of making sure that no one violates the Fair Housing Act there at the institution. So with that, we're going to head on to the next topic.
All right. So yeah, on this slide, we have just some various agency releases. So the variety pack here, if you will, of just some quick items to cover that were worth bringing to your attention, however. So this first one we wanted to include for those of you who might be getting questions about liquidity. So if there are any, perceived pressures or questions about what options are available, be that coming from management, be that coming from examiners or your own research and your own thoughts and seeing what's going out there, we wanted to let you know that the Fed has announced that it's going to make additional funding available, and it's created a new program, the Bank Term Funding Program, for this that will be offering loans up to 1 year as an additional source of liquidity. So again, something to take a look at if you want to find out more about that program in the link below. We also have another link here just below that. Not anything new for this one, but considering all of the questions that you might be getting and that actually we know you're getting, as we've been hearing from you, is this particularly from consumers who might be coming in and wanting to know about their deposit insurance coverage, how much they're covered, where their accounts fit, what categories of a deposit account coverage they go into, how to calculate it, and everything that goes into calculating FDIC deposit insurance coverage. We have a link to FDIC's deposit resources there on there. So FDIC actually has a great page for resources and really can answer just about any question that you would have about deposit insurance coverage, be it a question that you have in the rules, so FDIC's Part 330, or a customer might have just about what it is and how it works. And they've got summaries, frequently asked questions, at a glance resources, which are particularly good. And again, kind of in that infographic format on how you can just kind of quickly see the categories laid out. The ED calculator, so customers or you can go right in there and put out the accounts that you have, the types of accounts, any beneficiaries and so forth, and it will calculate that amount for you. And then lastly, there's a phone number on there to call FDIC so that ultimately the final question can be answered by FDIC if the customer has any about their potential coverage there. So again, nothing new, but we would recommend taking a look at that as those are excellent resources on FDIC's website. Then the next one here is a statement from FHFA. And so this is actually a delay of the DTI ratio-based fees that we had talked about a couple of months ago. And so this is a delay of the effective date now to August 1st of this year, 2023. And, I know we've heard from some of you regarding the operational challenges that kind of everyone's been looking at to see, okay, well, how are we going to, implement this? How are we going to disclose these fees? And again, just from an operational perspective, FHFA is aware of that. And that is why they've decided to make this delay so that we can work through that and see how this is going to be addressed. Then lastly, as Heather had mentioned, we just wanted to let you know that CFPB did update its HMDA reference chart since last month. Again, all of these links are in the description below. So take a look at any of those that might be worth your attention, and those resources are there for you. I will turn it back to Heather to cover our final item here.
Super. Thanks, Scott. So there are a couple different court cases we wanted to make sure were on your radar. From a federal standpoint, you're probably getting some of these questions from maybe your board members or other management. Just there's a lot of buzz around court cases, taking a look at whether or not the CFPB's funding is constitutional. And so we wanted to make sure that you had the latest and greatest on that particular topic so you could answer those questions by those who are asking. And so we can confirm for you that the U.S. Supreme Court is agreed to take up the review of the issue of whether or not the CFPB's funding is constitutional. And so we've provided you a link that gives a little bit of a nutshell of what the court is going to be looking at. Now, the court will not take that up until its next session, which begins in September time period. And so we're not expecting a decision until 2024. So we're going to be out there for a while before we have that particular topic answered for you. So right now it's status quo, that you want to keep your eye on what the CFPB is doing and what they're issuing, and understand that what they lead with, the federal banking agencies oftentimes follow. So it's still something that you want to consider. And even pending what the Supreme Court's going to finalize, there's still a lot of what ifs that we need to play through. But right now, status quo. And it's an important topic to take a look at because we actually now have split federal court decisions. So we have the Fifth Circuit that found that CFPB's funding was unconstitutional. We have a more recent Second Circuit decision which said that all is fine. They are funded correctly. So that further proves that there needs to be a review of that. All of the states' AGs filed opinions about why it's important to have this issue resolved. So no, it's going to be coming, but it's going to be a little bit of time. Then we also wanted to make sure you're aware of a positive outcome. So this is a Wisconsin Supreme Court case referred to typically as the atrium. And here, the important issue was centered around secured creditor interests and unsecured creditor interests, and how those interests get satisfied from the proceeds of assets that were sold in connection with a receivership situation. So very, very, very briefly, you've got a business customer of a bank that defaulted on a loan. And with respect to that loan, there was a perfected mortgage holder who had first priority. And then there were other parties, residents of this place that unfortunately went bankrupt. Those residents also had an interest in the proceeds that were going to be obtained because of the sale of all the assets of this atrium building. And the Court of Appeals gave the residents priority over the bondholders, the perfected mortgage holder. And so the issue at the Supreme Court level was who gets paid first. And we filed an amicus on behalf of the membership because we wanted to make sure that the order that is very clear underneath Chapter 128 of who gets paid first, second, third, etc., through a receivership situation, it first goes to the perfected mortgage holder. And we did not want that order to be disrupted because we've relied upon that order in the receivership situation. So the Wisconsin Supreme Court looked at the documents that were used in the transaction, agreed upon the language of what those documents meant, and in a unanimous decision, found that the perfected mortgage holder, the bank, they were in first priority. And because of that priority order underneath Chapter 128, the first priority goes to the mortgage holder, and the other parties, the unsecured creditors, will get paid later in time. But luckily, the court saw that the order in Chapter 128 is an important order, and that stays intact. So if you want more detail about that particular case, feel free to take a read of the March WBA Compliance Journal. We did include an article in that, so you can get the nitty-gritty about the case in that situation. So that was the kitchen sink here for March that Scott and I wanted to walk you through. Scott?
Yeah, thanks, Heather. So we can wrap up with that. And as always, we want to share with you all the resources that we have available on the WBA website. So compliance tools and resources, publications, training, and of course, the compliance hotline. So I wanted to specifically mention a couple new resources that we have this March. And so we talked about all of the FDIC deposit insurance coverage materials on the FDIC website, and we've created some resources as well that are valuable in addition to what FDIC has on its webpage. So on our consumer-facing webpage, where there are resources that you can share with consumers that you can print off and use, be it to hand out to them or tweak to your needs and what your consumers are looking for. We have a summary of FDIC deposit insurance coverage that you can use. And then we're also looking to create a new resource specific to, again, the questions that we are hearing from you, where customers are coming in, they want to know about whether they're covered, the types of account categories that they have, what that means, how that's calculated. And again, FDIC has great resources from the rule perspective and how all of that works, but we wanted to create an additional resource on how to approach those consumer interactions and how to, maybe put their mind at ease if they're concerned and walk them through that so they can understand that their deposits are insured and safe at your institution. So keep an eye out for that as well. But again, those resources are available on our website on the compliance page within the best practices library on the consumer-facing website as well. So thank you again, everyone. Hope you have a great March, and we will talk to you next time.